What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Tuesday. Happy Tuesday. And yes, I am on time tonight. I saw your messages. Quick question. How does my mic sound? I've been having issues with my mic all day. And yeah, that's why I didn't put out a video earlier. Every time I would play it back, it would sound really bad. So hopefully it's okay now. Just waiting for the confirmation. If not, I'll just put in my my headbuds, my earbuds. Okay, sounds good. Good. Okay. Where was I? Yeah. Happy Tuesday. Anyways, what do I have tonight? Three cases tonight. I've got two pro says that clearly use some kind of AI. I don't know if it's ChatGPT, but yeah. So they're fun. And then we have a lady that doesn't take being evicted too well. So that's on the docket too. Anyways, you guys want to watch some court? I want to watch some court. Let's watch some court. Yeah, no, don't do that. Don't do that. Okay. No idea why YouTube keeps shit. I don't know. No idea why they keep doing that. I don't know. We're just gonna live with it though. Okay, you guys ready? I'm ready. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick back flips. Let's go.
Portfolio recovery versus Nathaniel Bard.
Good morning, Your Honor. Mimi Kalish, appearing on behalf of the plaintiff.
Kalish and Mr. Bard, looks like you're there too. Are you there?
Yeah, I hope so. Try to figure out this computer stuff is Chinese to me. I'm not technology smart.
Hey, you're doing, I think I mentioned, you're doing a lot better than most here. So this is set for a motion for summary disposition today. Have the two of you talked at all?
No, I've never talked to this person. I've sent out some information about signed contracts with this company and what the sign off was, because I know the ally signed this off and wrote this off back in 2024. And this company, this collection company, decided to buy it up pennies on the dollar. Never told me what they paid for it. And been blowing up my phone 2 or 3 times a day about wanting to.
I'm inclined to.
Sharky. The actual going name that I was debating between was Court Crawling with Colin. That was the leading name that I was debating, but Coolin with Colin's on everything already, so I didn't want to just rebrand completely. So all I did was change my name. I didn't have to rebrand because the channel name has technically always been Coolin with Colin, but my personal name wasn't. So when I changed my personal name, it changed the main.
Proceed.
Yeah, okay.
So I don't know. We could talk or figure something out. I don't know. I'm not up to it. So.
Maybe it would help if you talk for him for a minute. Any possibility?
I mean, everything that's been represented is so.
Yeah, I think
he's got copies of everything that they sent to me in a letter that when I filed with you guys on a request of contract, and the contract was never sent to me that I signed for this collection. That was a request that I asked, and they sent me copies of all the receipts and a standard thing saying I'm liable because they pick up. I got a packet that's over a half-inch thick. So, I mean, I'm not saying that I haven't used.
I guess for both your sakes, I don't want to waste time either. If it would be helpful, I'll let both of you talk. If not, we'll just, frankly, proceed.
I'm prepared to proceed, Your Honor.
Okay.
I don't know
Mr.
when
Bard,
anybody wants to talk, so.
Mr. Bard, did you file a response to the motion for summary disposition? I have an answer. that you filed. But did you file a response to that motion?
Yes, I think I did. Me and my girlfriend sat down and wrote some stuff out as much as I can understand what was going on with the questions. Some of I had to Google, some of I've never been through this, so I'm not quite
Okay.
sure what's going on.
Well, I've got what on one of our scale forms, an answer that you filed. You have that. Was there also some other response for the motion that's up for today? I don't see one in here, so why I'm asking.
Well, I didn't know. I filed for you guys excuse me because I have a closed hand injury.
That's okay.
I apologize for my auto accident here. So I got some paperwork in the mail months ago, and I needed to apply to some questions, and I sent it back into the court, and they gave me a court date. And then when I applied for that stuff or filed for that stuff for you guys or answered the questions, I had my computer reach out for some of these 5 questions about, I got the name and address of the original creditor. I got stuff, but I asked for a copy of the original contract and agreement for bearing of my signature. And I never got anything like that. I got a copy. I got literally a big packet of just repeating receipts and payments that I've paid and a mumbo jumbo in the back. And then a big file that was basically a copy, fill, paste that probably goes up to everybody that's ever had to do this about saying that they picked up a contract or they pick up this, and this. I'm not a legal person. I apologize that I'm not making any sense, but nobody's ever talked to me about a settlement price. They just said, well, it's $1,800 plus court costs, which is $2,000. Where's that paperwork at? I know this was charged off back in 2024, and somebody picked it back up for pennies on the dollar. The creditor did, and now they're asking for $2,000.
Okay, and I do have the bill. I think what you're referring to, I do have a bill of sales dated May 20, 2024.
Yeah, if I'm reading that right. I mean, I got a lot of this stuff doesn't make any sense to me. I read a lot of it and it's just repeated.
Yeah, I understand. And a lot of those, see, there's also an affidavit that's count stated, it looks like.
The codes and a bunch of 7606, and then it was 2014 86. But if a bank or a credit card buys or sells off a creditor or sells it off, or not sells it off, or writes it off to their taxes or whatever, and then another creditor comes in and buys it for pennies on the dollar, where do I sign a contract owing the money for the creditor?
I can't give you legal advice. I'm just going to follow what the law is, and that's what I
know
can
that.
give you advice.
All right, welcome to the soft sit portion of this evening. This is one of those arguments that what I call soft sits, not sovereign citizens, but they're soft sits because they spend way too much time on Google. They find these snippets of things you can say in court, and they don't really understand what they mean. This guy's a perfect example. He's just using a line that he read on the internet. He said 100 times that he doesn't know what's going on, but yet he drops that in there. So he's doing research. I kind of think he's playing stupid.
You can't give me legal advice. I'm just confused. And nobody said, they're just like, well, just pay this. Nothing like, well, let's settle with this or settle with that. And nobody and they blow up my phone constantly.
Yeah, no, I understand, Mr. Mayor, but here's the thing. And as you're talking, I'm going through the motion that's set for today with all the documents that have been attached, which is what you're explaining as well. The original debt, and I just lost it here, was 18.
Yeah, I see the 1876-06.
Yep, something like that, somewhere in there.
Because when I filed this stuff with you up at the 67 District Court in Flushing, and they gave me the court date, they stapled everything together. I had another piece of paper that I sent out with them. They sent that back with me because there was a bunch of questions that I wanted from them in copies from
Casey, you
the
can't,
creditor.
I know, but it's gotta be in proper form too, so my staff wouldn't know what you provided. It's gotta be in, I hate to
I
do
don't
this,
understand
but
proper
it's
form.
gotta, I know it. And that's the issue, because that's, in fact, I see what you got. It says, please provide the following, and there's like 5, which you just described.
that's-
That was supposed to be an motion provided to the plaintiff.
I
You
sent a
just
copy
addressed
to
it.
them because they sent a copy back to me.
Yeah, I see that in your answer, but it's just, it's not really, it's not in the right format, so I
I
can't.
didn't know that. I know. I just, when I filed this stuff with the courts and I handed her a copy, she says, I'll put it in with the file and send
Yeah,
it out to them. And
that's
when
what
they
they
send me a
did.
file, they sent that back to me.
Yeah, well, I don't know who sent, when you say sent back, I don't know if it was through our court or whether it was through plaintiff.
The plaintiff sent me a packet
Oh,
of
I see.
repeating information. So they got my stuff that I filed with you guys, and then you guys sent it out to them. Well, when they gave me the stuff that I needed, there was no contract signed in there. It was literally just a repeat of paperwork. I wish I could just show you the packet because I got it behind me on a desk, on a table. It just repeated of all, hey, well, you paid this. This is what the credit is. This, and it just
Yeah,
added
sure.
up.
Yeah,
I don't know if I'm explaining it right. I apologize.
no, I know what you're talking
I'm
about. Yeah,
upset.
you're talking about the statements that you got on a
Yes,
monthly
that's
basis.
probably what it was. The statements.
Yeah,
And then they sent me another thing that was basically a copy and fill of standard whatever they have in a file. They just fill in the blanks. And none of it made any sense.
Ms. Kalish, I guess help me out a little bit. Part of the, I guess he hasn't filed a response. Let's just start there. So I understand that you've got your motion up today. It's a C9 and C10 motion, if I remember right.
And
Is that
I
what it
filed
is?
everything right, but evidently I didn't.
Well, I know, but I gotta hear from her too. Ms. Kalish, is it a MCR 2.116 C9, C10? I gotta
Yes.
find it.
And it's
Yep, here it
Kayla.
is, C9 and C10. Yeah.
It's Kayla. My name is.
Oh, Kayla,
Kayla.
I'm sorry.
That's
Kayla.
okay, Ted.
I'm sorry. I see all the
I'd like
documents.
an opportunity to speak if I could.
Yep, and I just got a question for you, and I'll give you a chance to go through it for me. The only one that's got some validity to it is the contract with a signature on it. I guess that's what I need you to argue more than anything else. You know, the original credit card agreement. So,
So,
if you could-
Your Honor, I think as Your Honor understands that use of the credit card, which the statements reflect, several purchases as well as voluntary payments under case law in Michigan supplants the need for a signed writing. Using the card, making voluntary payments on the card indicates that the card holder has assented to the terms and conditions of the extension of credit, and he's enjoyed the extension of credit and has used it over a matter of months and years and made
I haven't used
several
it over
payments.
months. It's just a couple months.
Sir, hold on. Let's hear your chance here. Go ahead.
At local businesses and gas stations and various purchases for goods and services. As far as the assignment, this contract is freely assignable. We've attached all the appropriate assignment documentation as well as it's page 64 of our 74-page motion and exhibits is a written correspondence to Mr. Bard dated May 20th, 2024 that notifies him specifically that this Ally credit card ending in 1227 was sold and assigned to Portfolio Recovery on or about May 20th, 2024. It gives the balance as 186706. Gives the date that the account was opened, which was December 12th, 2022, the date it was transferred, sold, and assigned to my client, which was May 20th, 2024, and provides the name and address of the assignee, Portfolio Recovery Associates, and a phone number and website. Notwithstanding that and the affidavit. So in some cases, I can't always sufficiently connect the dots between the original creditor and the assignee.
Fly Girl, thank you so much. Good evening, everyone. Thank you so much for the 3 months. That is awesome. Thank you.
In this instance, we have the assignment documents. We have the letter that was sent to the defendant informing him that his specific case, his specific account was sold and assigned. And I believe we've satisfied the threshold needed for a dispositive judgment as a matter of law, especially in view of the fact that no written response was filed. I do appreciate the fact that Mr. Bard is representing himself, but as the court knows, he is held to the same standards as if he were an attorney, and it's incumbent on him to follow the court rule and look it up or seek free legal aid if that's available in your county. But in this instance, we've shown several statements showing frequent use of the card, voluntary payments on the card, and the assignment documentation. So in the absence of a valid defense and no issues of material fact for the trier of fact to decide, I think the motion is appropriate and should be granted at this time.
I don't agree with it because I haven't had a signed contract. Just because they get a credit card that gets over and you say I used it for years, which I haven't had it for years, or I used it, is a signed contract. It was a signed contract with Ally, not the collecting agency. Now, if somebody bought a contract that's pennies on the dollar that you guys do all the time, which is fine, whatever. And I asked for a signed contract for you guys where I agree to pay you guys versus Ally. I owe the money for Ally, that's fine, but they paid it off. They wrote it off on whatever they wrote it off on. I'm not an attorney. I don't look at this stuff and say, oh, I got to do this, and this. When I got a packet in the mail the first time from, I think it was the courts, I literally had to try to Google what the questions were because the questions weren't out understanding. When I turn around and asked for copies of these 5 questions right here, you guys sent me a packet of stuff that I have no idea. It's all Chinese. You're expecting me to sit down and read law when I don't have any college degree to understand the law or who I need to contact? None of this ever makes any sense. You guys send out a packet that's just repeated of, oh, it's this receipt, that receipt, document, or statements, or whatever they are. And then you had a packet saying that you bought this on this time and that time, but it was charged off from Ally. So you're asking full payment of this with no negotiation on anything. I don't understand what questions. I literally looked through the pack 5 or 6 times. And then this morning at 7:30, 8 o'clock, I've been looking through the pack to gather up some paperwork. And there was nothing in there that says, can you please ask or fill out these questions and send it back to the attorney or the creditor, whoever I had to send it back to. Hell, I didn't even understand the packet that I got from the 67th District Court. I'm sorry. I don't.
Yeah, Mr. Bard, but the problem, yeah.
Yeah, but you just admitted that you spent time Googling. You Googled a response because that response that you keep saying over and over again is something that you would only find by Googling. You didn't make that up. Like, I mean, yeah, it makes sense. Hey, I owe Ally $2,000. This credit card, this collections company bought it from Ally for $250 because Ally wanted to get rid of it, and then they wrote the rest of the debt off. That doesn't mean that you owe, you can just pay $250. It blows my mind that this is an argument this guy's making, and he's already admitted to the credit card. He's already admitted to it. I mean, it's just this kind of stuff frustrates me. It really does. Sparkle Poots, don't, dear YouTube, don't mess with names. You've no idea. Thank you, Sparkle Poots. I appreciate it. Yeah, the names thing's weird. I don't know why they do it. My first assumption it had to do something with bots. I don't know if that's true or not, but it might be. Who knows? Cheshire Cat, I have infected the YouTube code yet again. Yeah, we can blame Cheshire. It's Cheshire's fault. All right, let's finish this one up. We're almost done with this one.
I'm not going to belabor the point.
Sorry.
And I'm not pointing fingers, but I mean, I got to follow the law for everybody. You're representing yourself. Had a chance to have an attorney involved or whatever.
I could
reason.
afford an attorney. I'd just pay this off.
I understand. Either could not afford one or decided not to, whatever the reason is, you're here by yourself and I've got to follow the rules. Fair manner for everybody. Do you find this motion is filed pursuant to MCR 2.116C9, C10? There is a significant, and Mr. Barr's right, there is a significant amount of documentation that's been attached to the motion. For the record's sake, there's been no response to the motion for summary disposition today. All the attached documents, there is, in particular, I don't usually get this either. I've got a back page of the bill of sales, also showing Ally Bank and portfolio recovery signatures on that, as Ally Bank being the seller, purchaser being portfolio recovery. There was also a notice. I see a notice that was sent out, notification of assignment from Ally Bank to portfolio recovery that was also sent to Mr. Bard, which is, I have to say, sometimes missing out of these motions. There's bill of sale attached, the attached documents for individual billings that were sent to Mr. Bard all have the same address, 9460 Maxfee Road, same address that Mr. Bard has used today. That's all consistent, showing use of the card, showing payments that were made throughout a period of time. Based upon the totality of all the documentation and the answer complaint, the complaint itself, you find there's no genuine issue of material fact pursuant to MCR 2.116C9 and C10, based 9 being based on the pleadings, 10 being based on the pleadings and all the attached documents, no genuine issue of material fact. Grant motion to plaintiff for an amount of $1,867.06 plus court costs $147.80 for a total of $2,014.86. Judgment for plaintiff in that amount.
So do I pay you or them?
Well, it's going to be to portfolio, but I'm not sure how that gets handled.
Payable
Awesome.
to
There was
Stillman
just
Law
no,
Office.
there's no, I don't even know, try to say the words. I apologize.
Yeah.
I got a massive closed head injury. I can't think.
Sure. Well, you can, I'm sorry, who does he get a hold of? I assume he still gets a
Stillman
hold of
Law
you guys,
Office.
doesn't he? Yeah.
I'm not paying all this at one time.
No,
Sir, you can, that's something for outside of here, whatever that is, I'm ordering that this month is owed, okay?
does the court have the order that was included?
In fact, I was gonna say, I've
Okay.
got an order, I've signed that order, and we'll send a copy of that to everybody,
Very
okay?
good. Thank you, Your Honor.
All right, good luck
Where
there.
was the question?
You
Good luck,
can
Mr.
call our
Bard.
office and make a payment arrangement. Not all judgments are collectible. If you have the ability to pay, we'll gladly take payments. You can
I don't know
always
how to get a hold
petition
of
the court for payments.
I'm sorry, what? You
You
said go to the
can-
court?
You can ask the court for a payment plan that would spare you from having wages garnished. You can make payments, not make payments. Some judgments are not collectible, but
I
you
don't
do
understand
that
when
through
a
our
judgment is
office.
not collectible when he just turned around and said it was collectible.
Sir, I didn't take any position whether it was collective or not, just that the
Oh.
debt's owed. Okay?
Right. If you
You
have the
honestly,
ability to
best,
pay and make payments, you can call our office and make those arrangements.
How do I get a hold of you?
Our number's on all the pleadings, Stillman Law Office.
Okay.
do
Okay.
you want it? I can give it to you. I've got it right in front of me. Just happen to have it right here if you need it. Do you want it?
I think I got it. Yeah, just
Sure.
yeah, give it to me if you can.
Sure. Two.
This guy's pouting like a baby now. But yeah, you spent the money, man. I mean, good for you for turning up to your court hearing. Shouldn't have listened to Google that much, though. That's why you're frustrated. You thought you were going to win with just dropping some things that you didn't understand. But he showed up, doesn't have a default judgment. Hopefully, he gets this paid off. All right. Moving on. Now we're jumping down to Texas. We're in is it Judge Holmes? I believe it's Judge Holmes. We have eviction gone bad. Yeah, there's someone not very happy. Hasn't paid rent in months and not very happy about the outcome here. Ed, thank you so much for the 7 months. He should challenge jurisdiction. That would help. That would absolutely help. You know, when you throw multiple nonsensical arguments into one sentence, you know, it confuses everyone and you know, they have to dismiss the case. That's how that works. Thank you, Ed.
Next case will be 20.
I don't know about this week. I do know last week that he was off for the rest of. I think he was on the bench Monday, maybe Tuesday, and then I remember someone said something about he was off the rest of the week, which made sense. But I don't know about this week. But it's that time of the year. It's that time of the summer where everyone's taking vacation. So wouldn't surprise me if he's out this week, or maybe he shows back up tomorrow. Who knows?
25-963. That's Weedemar LLC versus Mary Valdez.
On the Judge Simpson note, I got a shout out from Judge Middleton this morning. I forgot to clip it. Judge Middleton said hi to me. I felt good. I just wanted to share that. That's it. There's no more of this story. I just said good morning in the chat and he called me out. That's it. All right, let's go.
Do I have someone here on behalf of Weedemar?
Yes, Your Honor, Joseph Bays. Good morning.
Good morning, Mr. Bays. And do I have someone here on behalf of Mary Valdez?
Can I speak?
Yes. Good morning, Miss Valdez. I can hear you.
Good morning. Yes, ma'am. This is a very complicated case.
Okay, well, Miss Valdez, Mr.
Yes.
Bays has to tell me why the case is happening, and then you absolutely get a chance to explain it, okay?
Oh, okay.
All right. Mr. Bays, tell me why the eviction is being sought by the landlord.
It's for non-payment of rent, Your Honor. No rent's been paid since August 24. A monthly rent is $830. The original lease was from November 21, October 22. Since then, Miss Valdez has been month to month. On April 14th, my client, Weedemar, gave a notice of non-renewal through fixing to the door and by email.
Of
Per the
what
lease.
year?
Of this year, Your Honor,
She
25.
hadn't paid rent since August, but the landlord still gave her a non-renewal.
No, she gave it. She was month to month. The landlord just hasn't
I
saw.
get that, but just what I'm hearing, Mr. Bays, is that October of 2022, the lease came to an end.
Yep.
And then it went month to month. So every month it renews. She
Correct.
stopped paying rent in August of last year,
Yes.
but the landlord didn't give her a notice of non-renewal until April of this year.
You're correct.
So
Your Honor.
August, September, October, November, December, January, February, March, 8 months of nothing. And then we're not renewing as opposed to a notice to move out.
Oh, we gave a notice of non-renewal and then a notice to vacate after that. So she gave her 30 days to kind of get her affairs in order. And then after that, on May, I believe it was May 15th, that's when she became holdover. And at that point, we gave On June 2nd, we served the 3-day notice to vacate.
So in April, y'all said it's not renewing. She had until the end of May to get out. She didn't, so you gave her 3-day notice on June 2nd?
That's correct.
Okay. Was there any subsidy on the 830?
No.
All right. I'm curious, Mr. Bays, what is your plaintiff seeking?
Rent since she stopped paying in August 24. Rent's $830 a month.
What was the reason for the delay of 8 months?
I'm not sure, Your Honor. I think Ms. Valdez has been there for a while. I think she was paying beforehand, so my client, for whatever reason, allowed to kind of slip longer. But obviously, it hasn't been paid in a long time now.
Were any partial payments made since August of last year?
No, a ledger was included. I think as A3, one of our exhibits. No partial, and of course, we're only seeking the rent today, not any late fees or anything like that.
Well, that's by law. In addition to rent, are you seeking anything for fees?
Yeah. I believe my fees were $3,000, Your Honor.
For what? With all due respect, Mr. Bays, this is a very simple eviction for non-payment. It took 2 pieces of paper. What is $3,000 in your fees?
That's just what my client incurred going back and forth with our office and with me. But
with all due respect, love lawyers. I won one. I want to give you what I can't in good faith give $3,000 on what is really $1,000. We could talk, right? I give you 4 hours at $250 or something, but I just can't get there, especially given that your client definitely could have gotten to the situation a lot faster. Now, I appreciate it maybe that there's a reason for that. So I understand, Ms. Valdez. We want to hear from her. All right, Mr. Bays, thank you. You've answered all my questions.
Understood, Your Honor. Thank you. Appreciate it.
All right, Ms. Valdez. Mr.
Yes.
Bays is here, and he's here representing the landlord. And what the landlord is saying is that this is a non-payment matter, ma'am. So you've behaved well in your apartment, but they said that rent has been behind. So the first question is the rent every month $830?
Okay, he's not telling you the whole story.
Ms. Valdez, I want to hear the story. My first question is, how much is the monthly rent?
She told me in April that the rent was going to be $11.85.
Sure, but what was it when you signed your lease in November of 2021, ma'am?
$830 back then, yes.
Okay, and what's the last time you paid rent in the amount of $830?
The last time I paid rent was last year. I had been paying for every single month when I got a notice from the prior owners that I owed them $10,000. That's where all the confusion came in. I went and personally talked to them, and I said what was going on, and they said they were charging me late fees and they were not applying my rent toward my rent.
I'm not worried about the late fees. So let me, Ms. Valdez, we can work through this quicker. How do you normally pay your rent? Do you write a check? Do you pay with a credit card?
Money orders. I was doing money orders, and I told Crystal the whole information. She said she was going to check into it. So I assumed I was getting credit for those $10,000 that I had paid.
Ms.
That's
Valdez,
what I assumed,
Ms. Valdez,
because there was no communication.
Ms. Valdez, when's the last time you provided a money order to the landlord?
Last July.
Last July.
To the prior landlord.
Okay, so it would be correct, Mr. Bays is correct, that you have not delivered any checks to the landlord since August of 2024.
Correct.
Okay.
Because I thought I was getting credit again. I thought I was getting credit for the money that was taken because they did say that the other guy had embezzled that money. They're all aware of that. They're aware of this, so I'm just kind of a little upset that they're not telling you the whole truth.
Well, I'm trying to get there, Ms. Valdez. So me asking you questions, I'm going to redirect and ask a few to the plaintiff's counsel again. But here's my question. You agree that you have not paid rent since August of last year?
Yes, ma'am. Yes, ma'am. I will not lie on that.
Paying rent, which you believe you've already prepaid that rent?
Yes.
Okay. Had you been writing checks for twice the monthly rent in the months before that?
No, ma'am.
Has there been any month since November of 2021 where you paid more than $830?
Yes, that's when
When was that?
I had paid from then to 2024, $10,000.
No, that's not what I'm asking, Ms. Valdez. Do you have more than one money order each month for 830? Or did you ever get a money order for, say, 1660 or for any number higher than 830?
Every month was 830. I was paying 830 every month. I was sending in every month my rent.
And they agree with that. What they said is you stopped paying in August of last year,
Yes,
and you said the
yes,
same thing. So my
yes.
question is, if you believed you had paid in excess, do you have proof that you'd paid more than 830 a month? Because if you only paid 830 every month, then you can't have paid in advance. You've only been paying current. And if you stopped in August, then you are behind on the rent.
Well, that's where I'm a little confused because what happened to that money
That you paid for
that
your
I
rent,
was
ma'am.
paying?
Every month you gave them 830, and that covered the
Yes.
upcoming month. And then
Yes.
you stopped paying in August.
Yes.
So you owe the money for August and every month since August of 2024.
Well, I guess if they're not going to give me credit for the other money.
Ms. Valdez, I'm not sure how you would have gotten credit for additional money if you had not paid more than 830 each month. So before August of last year, was there a month where you paid more than $830?
No,
Then
no.
it's not possible you paid in advance, Ms. Valdez. So I do find that it's correct that the plaintiff's assertion, as you've acknowledged, you have not paid rent since August of last year. Okay, all right. So August, September, October, November, August, September, October, November, December, January, February, March, April, May, June. We're at 11 and 12. Ooh, a whole year at the amount, huh? Judgment for the plaintiff, $9,960.
Oh my God.
Ms. Valdez, I find that that is rent for the last 12 months at the amount of $830. There's no late fees in that per the judgment today. The landlord, I'd say, Ms. Valdez, I'm going to encourage you to go and talk to legal aid about it. In addition to the $9,960 in rent, I will award $1,000 in attorney's fees. Mr. Bias has presented his case successfully. He's had all the information ready to go, and the notices were sent. The only additional money that you would owe, Ms. Valdez, is there's a small cost of court, which is usually about $100 or so.
Hey now, that's 99 cents. I would happily give her $1 to be a member to join Members Monday. But yeah, don't throw me in this. I didn't do this.
Either party can appeal my decision. I would set the appeal bond at 3 times the rent, $2,490. Ms. Valdez?
May I say one more thing?
Absolutely.
I showed her when there's a lot of violations going on in this apartment, and I showed her in April. I've been without AC all month. I'm on dialysis. I have a lot of health issues. I've texted her and emailed her, and they're refusing to fix the AC. Why can they get away with that when
Because you're behind on the rent. Ms. Valdez,
yeah, so they don't have to,
that's the answer.
they don't have to
Texas
fix
law-
my AC?
No, because you haven't paid them the rent. Texas law
Well,
is really
they're
strict
going to
on
be in
this.
trouble with the
They're not in
Texas
trouble.
board.
That's the
I
problem,
already
Ms.
called.
Valdez.
I already called, and they're not.
Please
They
contact
told me it's
legal aid
against the
then.
law for her not to fix my AC.
Air conditioning is not considered a health or safety issue in Texas for the most part. If your lawyer thinks they've got a claim, call them today and ask them about it. But typically, I don't find that's ever sustainable unless it is with infants or a nursing home. We have a prison that's still on air conditioned in the state.
So if you have health issues, that doesn't matter.
Texas says you're a grown person, you can walk outside.
That's why the landlords
know.
are the way they are.
I-
They take advantage of the
Valdez,
customers.
I don't disagree with you. I once had a judge when I was an attorney who told me the exact same thing that I just said to you, counselor. Air conditioning isn't required in Texas. We settled this country in a wagon. And then, with love and respect to that judge, he canceled court the next week when the air conditioner went out in his building. You can't
So
make
if
that
there's
up.
a-
So,
if
Ms.
there's a
Valdez,
fire-
I absolutely empathize.
If there's a fire here due to the furnace, they're not liable.
Fires and furnaces are different than air conditioners. You have to have heat. in
Well,
this
the furnace,
house.
I showed her the furnace. The gas company has tagged it 3 times.
Ms.
3
Valdez,
times.
please contact one of those legal aid providers and get assistance in the next 5 days. Do not hesitate to do that. I'm going to give you the
Okay.
final information, okay?
So where do I go from here?
Ms. Val, I'm trying to explain that, okay?
Okay.
You have 5 days beginning tomorrow to appeal or get help from legal aid. I would, not advice, just information. Don't wait till day 5. Today,
Okay.
call. And when you call them, say, I was evicted this morning. Judge Holmes signed the order. I have been evicted. I have 5 days to appeal. That way they will understand that you have very little time to get this fixed and to find a new place. Okay?
Yes, ma'am.
We will email you when you checked in. Did we get a good email address from you?
Are you talking to me?
Yes, Ms. Valdez. When you checked into court, did my clerk get an email address from you?
I gave them the email address. They just never sent anything to me.
No, Ms. Valdez. I'm asking today when you arrived in this section.
Oh, yeah, I gave it to the people earlier.
Fantastic. Then we will email you this afternoon, just after lunch. You're going to get a copy of your order, and it's going to include information about appealing and legal aid that you can call.
Okay.
If you don't do anything, if you just did nothing, 5 days beginning tomorrow, on day 6, that's the soonest the landlord can legally come in and make you move and remove your items.
Okay.
Okay.
And if I appeal it?
You can arrange to make payment with the landlord. You can talk to legal aid about options. You have several things ahead of you. But if you don't do anything, 6 days from now, the landlord would be able to come in and take back possession of the unit. Okay, ma'am?
So they're going to come and kick me out in 5 days, basically, if I don't appeal it.
That's the soonest they can do it. The law says they have up to 60 days to do it. And since the landlord has taken an entire year to evict you for non-payment, I don't know what that means about how long.
Well, you got to remember, they weren't in charge a year ago.
Okay.
Like I said, the other people took the money.
That might be part of it. Ms. Valdez, very good luck to you, ma'am. Please remember, we're going to email you this afternoon with information. Reach out to those providers and let them know your situation. But if you don't do anything, you have at least 5 more days beginning tomorrow. Today is not part of that 5. Okay?
Okay.
Good luck,
Okay.
ma'am.
Thank
Mr.
you.
Knight, thank you as well.
Can I get out of the meeting?
Yes, Ms. Valdez. All parties are excused now.
Thank you, Your Honor. Have a
Thank
great
you,
morning.
sir. I appreciate
Take
it.
care.
Have a good morning, sir.
You too.
Good luck to everyone.
Thanks.
Then we're going to be 25-9.
Oh, that one was fun, right? Yay, we like fun around here. I mean, it's not fun that someone got evicted. Just that was kind of tough to sit through. Another Squid, thank you so much for the 5 gifted memberships. Welcome to the 5 new members. Thank you so much, Another Squid. That is awesome. Very generous of you. And last case of the night, Judge Dad. We've got another guy who enjoys Attorney Google. Let's go.
2501675 RGC. All right, Mr. Haroni, your name?
Good morning, Matthew Haroni in pro per.
Ms. Ford?
Good morning, Your Honor. Corrine Ford on behalf of the defendant, Adam Ramdo.
So I was off yesterday and I had no idea how lengthy these motions, and I must have somewhere in the neighborhood, I don't know, could be wrong, but I gotta have 300 pages here between motions and exhibits. I'm not even sure I know where to start. I'm not sure. I'm gonna try to plow through this, but I wish I would have had more time, to be honest with you.
Hey, is this video skipping for anybody else? It is skipping really hard for me. Maybe it's not. I don't know if it's playing smoothly for you guys or not, but it is. I think I've heard 5 words the judge has said in the first 30 seconds. Why it's skipping like that? At least for me. Just waiting. Somebody respond. Oh, it is skipping. Okay, I'm rewinding it. We'll rewind to that break. Hopefully it's not the video. It might be the video. Maybe I got a bad copy. Okay, let's try this again.
2501675 RGC. All right, Mr. Haroni, your name?
Good morning, Matthew Haroni in pro per.
Ms. Ford?
Good morning, Your Honor. Corrine Ford on behalf of the defendant, Adam Ramdo.
I was off yesterday and I had no idea how lengthy these motions, and I must have somewhere in the neighborhood, I don't know.
Yeah, I don't know. It's still happening. All right, I'm gonna try this one more time. It's happening at different parts. So this is either internet issue on my side or a StreamYard issue. I don't know because it was skipping at different parts than it was the first time I played it, and now my internet signal just dropped. Is this your fault? I'm gonna wait a second until my little internet meter pops up a little bit, but it's Cheshire Cat's fault. I sound robotic at times. Okay. Yeah. I was having issues all day today. I tried to record a video for about 2 hours, and every time I would listen to it after I recorded it, it would be robotic and it would sound like crap. So this is just all right. You know what? I'm just gonna play it. Hopefully we can get through this. But yeah, I'm just gonna play this. It seems like that kind of night. Sorry, everybody.
2501675 RGC. All right, Mr. Haroni, your name?
Good morning, Matthew Haroni in pro per.
Ms. Ford?
Good morning, Your Honor. Corrine Ford on behalf of the defendant, Adam Ramdell.
So I was off yesterday and I had no idea how lengthy these motions, and I must have somewhere in the neighborhood, I don't know, could be wrong, but I gotta have 300 pages here between motions and exhibits. I'm not even sure I know where to start. I'm not sure. I'm going to try to plow through it. Best I could. I guess I'm going to start with your motion to strike the amended complaint. And I want to ask you, so do you want to start with that?
I think that makes sense, Your Honor.
I would agree with you from what I not amend the complaint properly, okay? But why not allow leave to file the amended complaint?
Well, at this point, if you're going to allow him to file leave to amend the complaint, then our motion for summary disposition is basically going to be moot.
Well, I understand that.
So we'll have to refile that motion.
You're not telling me venue isn't proper here though, right?
It is. Mr. Randall does not live in Wayne County. He does not work in Wayne County.
Well, doesn't he
lives
work?
and works in Oakland.
Wait a minute, doesn't he work in Wayne County if he does conduct business here? He's representing a condominium association.
He does represent a condominium association that is Wayne County, but he lives and works in Oakland County.
This is terrible. I don't know what's going on. I don't know if the internet gremlins have come back at this, because this is the perfect time where my internet would start blipping. It just hasn't done that for about 6 months. But this is terrible. It keeps freezing for me, and if it's freezing for me, it can't be clear for you guys. There's no way. Let's just try to force it. If this is terrible, then I'm just gonna call it a night, and I'll replay this case tomorrow. But look, I'm gonna try to get through it. It's a good one.
I know, but it's still one of the prongs is resides or conducts business, right? Does he not conduct business in Wayne County? I mean, if you want to say, Judge, I think that the venue is proper, but for the convenience of witnesses and parties, I'm going to order that I'm going to ask you to transfer the case. You're going to have to tell me why it's more convenient for a case to be transferred to another court when all the witnesses, if any, are here. I mean, where are all the witnesses? I mean, you can't say, you agree he conducts business here, right? That's one of the prongs.
Correct.
Okay, so venue on its face is proper. The only way to do it is say for the convenience of parties and the witnesses that it's more convenient to be in another jurisdiction. So if you're going to tell me there's that I'm wrong. You can tell me I'm wrong. Judge, here's why I think you're wrong, and I'll be glad to listen to that. Let's start with that aspect of this.
Well, I think that is going to actually depend on if he's allowed leave to file the amended complaint and which claims, if any, survive after we refile a motion for summary disposition. Then it may be dependent on what witnesses need to be called. Because if all of the claims are against Mr. Randall may be the only witness other than Mr. Haroni and his wife.
Well, that may be, but look.
I mean, the venue argument goes, I mean, that's in regards to the motion for summary disposition. So if you're going, I mean, so I don't know if that even needs to be decided today.
Well, it doesn't, but you probably should have filed a motion to change venue if you were serious about it, rather than just saying venue is improper in your summary disposition motion, right?
Okay, understood.
Sir, I read some of this, and I read it, when I say I read some, I read a lot of it, but let me just pull out something here. Give me 1 minute, please. This was a lot to try to digest. What she's saying when she says you're not the real party in interest is that any of these fees, any claims under the Fair Debt Collection Practices Act must fail because you're not the one that was assessed the fines. Is that not your argument, Ms. Ford?
It is to a point, and also there were no debt collection actions taken. So at all. So I mean those claims don't even apply.
So you're not really the real party in interest here on most of these claims. I mean, look, you do what you want. If you want to do this, that's fine. And I'm not trying to discourage you, sir. I'm yet to see anybody do this competently. I'm yet to see any improper party, maybe one or two in my 30 years here. Now I know there's a lot of things on the internet now, and we can pull things up and read them and think we understand them, and maybe you understand them better than I think you understand them, or understand them better than almost any improper party can understand them. I don't see a real good claim here, sir, to be honest with you. From what I've read, I could start over and simply strike the amended complaint. I could do that because you improperly filed it. It's late. You only have 14 days. You can't just start filing complaints, amended complaints after that time period with no leave from the court. Now, I'm going to talk, and I'm going to say to you two this. Is there a way the two of you think you can be civil and go into a breakout room and talk about this or not? If you can't, I understand. It's okay. That's why I'm here.
Yes, Your Honor, I can.
I'm sorry?
Yes, Your Honor, I can.
Do you want to try, Ms. Ford? See if you can resolve it right now before everybody spends a lot of time and a lot of money. It's not, and I'm not referring to myself. I'm referring to your client and you and Mr. Haroni. And maybe there's a resolution. I don't know what it would be, but maybe you can try. I'm telling you, sir, I don't know how any of these acts constitute slander. I mean, I suppose if they're, or libel rather, I suppose if they're defamation. I suppose if there were untruths that were stated, falsehoods that were stated by a lawyer, and it harmed the reputation of somebody, on that count, you might very well be the real party in interest. But what he was doing was communicating with your spouse by letter and saying, these things can't go on, they violate the bylaws. And if go ahead.
Respectfully,
Saying you did. I don't know if you did or not. I mean, there's a lot of things in here about recording devices and cameras, and that would, on my reading so far, would be a violation. Look, I'm kind of rambling here. Do you two want to go into a breakout room and see if you can resolve it? If you don't, I understand.
yes, sir.
We can, Your Honor. Just one more thing, though, before we do that, going back to the motion to strike the amended complaint, there was another part to that motion, and that was to seal Exhibit 22. That was involving the documentation that Mr. Randall submitted in response to that was filed against him by Mr. Haroni and the Attorney Grievance Commission. So that's a confidential process. So we would ask that exhibit be sealed.
And that's Exhibit 22.
Exhibit 22 to the amended complaint.
Yeah. Why don't you two, I'm going to take that up, and I tend to agree with you.
All right. I've never said anything publicly about this, but this is a rude statement. And I know that you didn't mean it the way that it comes across to me, but I love Lone Wolf. Lone Wolf's awesome. I'm friends with Lone Wolf. But this is a rude statement. To say it in the chat that said, you know what? I like this person better than you. I'll see you later. Like, that's... It happens almost every night. Someone says this, and I just want to say it. It's a little hurtful. I'm just going to say that. It really is.
I'm going to take that up. Why don't you two go into a breakout room right now and see what you can resolve, if you can resolve it. If not, come on back in. If it breaks down, I'll call your case immediately, okay?
All right. Thank you, Judge.
Thank you. All right. So there's no opportunity, no chance of resolving this, correct?
No, it does not appear so.
All right. So what would you like me to address? Let's start with that. You want me to rule on your motion to strike the amended complaint and to seal the document pertaining to his communication with the attorney grievance?
Correct, Your Honor.
Mr. Haroni,
Yes.
do you acknowledge that you did not file, after reading their motion, your amended complaint appropriately?
Your Honor, I may have been confused, but I did file the amended complaint after I initially filed in small claims, and then when it was removed to general civil, it was within 14 days of that removal.
But you have to file within 14 days. That's not the 14 days. That was an order.
All right. I just want to clarify real quick. Yeah, I'm not saying that, if you have to stay here. I'm not forcing anyone to stay here. If you like someone else, by all means, go hang out there. I appreciate that you hung out here. Just when you say it in the chat, that's when, I see that. It's like, come on, you don't have to. You can just go and hang out. I would never know. Really.
That was, they're supposed to answer the complaint within 14 days. You want me to seal this record, identify the interest, counsel?
Yes, it's Exhibit 22 to the amended complaint. That is a document where Mr. Haroni had submitted a request for investigation against Defendant Randall with the Attorney Grievance Commission. That request for investigation was dismissed back in May of 2025. So attached as Exhibit 22 was Mr. Randall's response to that request for investigation. The attorney grievance process is a confidential process for reasons that the judge is probably well aware of. And so we just ask that that document that was produced in that process be sealed from public.
All right, and you
Thank you, Thorena. I appreciate it.
received this, correct me if I'm wrong, Mr. Haroni. Did you receive this when the grievance commission told you they were not going to take any action against Mr. Randall?
Yes, sir.
What is the relevance of that to any claim or count that you have?
Your Honor, the statements that he made in his admissions to the AGC are full of untruths and speak specifically to my family and my children.
Okay, but what? Okay. Ms. Ford, let me ask you a question. Again, I hate to keep apologizing, but I am going to apologize if I haven't already. I've read this, but geez, oh, Pete, my secretary tells me there's 400 pages here. So I did not go through this thoroughly, but do you agree that if any of these claims survive, that he could at least use the statements made to the Attorney Grievance Commission by the defendant as impeachment evidence?
No, I don't believe so. And all of the statements made in that document are taken from other documents that are already in play. I mean, that's just a recitation of the facts that occurred. So
Well,
those facts are alleged in other documents. I don't think it's necessary to use what was in play with the Attorney Grievance Commission at all in this lawsuit.
well, look, let me just see this for a second. Let me look at this for 1 minute. Give me a second.
Sure.
Is there anything in here, sir, that you would need, that you can't prove otherwise?
I could write an affidavit regarding the contents of the AGC response, but I redacted the confidential information, and those responses only contain information about this case and these facts.
All right. All right, I'm gonna strike the amended answer to the amended complaint. If you want to file an amended complaint, you have to seek leave of the court. So I agree with the defense. The amended complaint is strict.
Oh, my mic was on my head. Yeah, he is struggling. He said it at the beginning. He said, I was on vacation. I got back yesterday. I walked into a 300-page file, and I struggled to get through it. So yeah, he's struggling with this entire case. 300 pages. You know, it's like, hey, I just got back. Like, oh, wow, 300 pages. I guess let's go. You know why I'm paused? Look at some milestones. Oh boy, latex. Thank you so much for the 2 months and the latex. Thank you so much, oh boy. I do appreciate it. And Cassie for 3 months. Thank you so much, Cassie. That is awesome. Thank you. All right, let's keep going.
From the record. In the meantime, since I'm striking that, I'm also, as of this time, ordering a sealing of the Exhibit 22, which is the response of the defendant to the Attorney Grievance Commission. That's the one you're referring to, correct, counsel?
Correct.
So the motion to strike amended complaint is granted. You're going to have to see.
Oh, I'm absolutely going to respond because you said don't respond. Yeah, no, I didn't mean to say that you have to stay here. Like, yeah, and that's why I tried to correct myself. Like, I don't want to sound like I'm being a jerk. But you don't have to say, "Hey, I'm going to this other channel they just started." That was the rude part that I found. If you need to go, you're just like, "Hey, guys, I got to go. I'll see you guys later." All right, you'll get a bunch of buys. Yeah, and I'll say bye to you. But it's the announcing that you're leaving to go to another channel. I'm just asking why. Yeah, that's it. But yeah, if your wife walks in with a Victoria's Secret bag, you better go. I think there'd be problems if you didn't.
Seek leave of the court. In the meantime, I am sealing Exhibit 22 as referenced in the documentation here. And if you think that that is going to be something that you need to focus on, then you can, after you seek leave and acquire leave of the court, you can ask me to unseal that. But I can't imagine me changing my mind, but I will keep an open mind on that. If you're going to seek leave, you better do it quickly.
Okay.
Now, this seems so personal to me between what is going on here. It just seems very, very, very personal. I'm just going to tell you right now, that debt that they were attempting to collect was not against you. She's right. You're not the real party in interest. I don't know how you're going to get this to libel or slander or any kind of defamation based on anything that I read. But again, I'm telling you both, I have not read this in detail like I will before the next time. So you pursue this as you wish, but you have to have a valid claim, Mr. Haroni. Okay, otherwise you're subject to sanctions. That's all I'm going to say at this point. Prepare your order, Ms. Ford, send it over, and we'll go from there. Anything else, any clarification that's needed, Mr. Haroni?
Not at this time.
So you're not to distribute that document. You understand that. I'm ordering that sealed. You understand that?
Yes, Your Honor, I understand.
Okay, Ms. Ford, anything else?
Just for clarification, so in regards to the motion for summary disposition, are you denying it? Are you holding it in abeyance?
I'm not going to even rule on it. I'm going to give him an opportunity to amend his complaint, in fairness.
Okay, and then go from there? Okay.
Correct.
All right, understood.
Thank you very much. Have a good day.
Thank you. Have a good day.
Bye now.
Bye-bye.
All right. That is it. Got a few super chats real quick. Phil, thank you so much. Words are hard. Words are very hard. Thank you, Phil. And Dr. JD, weekly rant on Chris's. Thank you. I appreciate that. I feel like that joke's not going to go away anytime soon, and I don't mind. But thank you for the super chats, guys. All right. That's all I got. Tonight. You guys are awesome. Thank you so much for hanging out. Sorry for my little rant. It wasn't necessary. I see those kind of comments almost every night, and just decide to say something. But it's not that big of a deal. It really isn't. Yeah, that's it. Words are being really hard. Thank you everybody for watching tonight, and for the super chats, gifted memberships, membership milestones, mods. You guys are awesome. I have it set up to raid Credence and Mikey. And that is not because of the Lone Wolf thing that just happened. I never get a chance to raid Credence and Mikey, and they are live. Chances are I'm going to go over there. They're going to be finished right when I get there, but it's a chance to raid them. So, yeah, Lone Wolf is also live. We found that out about 10 minutes ago. You guys have a great night. I will see you tomorrow. Got 2 soft sits on the schedule tomorrow. I'm not going to spoil it for anybody. I'm not going to tell you. There's 2 soft sits on the schedule. Both of them are good. You guys are going to be happy. Okay, that's it. Until next time, bye.